Good morning, everyone. Welcome to WorkCover Queensland's first common law webinar for the year, titled 2020 Personal Injury Case Law Wrap-Up. My name is Hannah Staunton. I'm a lawyer at WorkCover Queensland, and I'll be your host for today's webinar. Before we get started, I'd like to acknowledge and pay respect to Queensland elders, past, present, and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters, and community. Today's webinar will run for approximately 1 hour with some time for questions at the end. If you need to leave a bit earlier, this session will be recorded and we will send a link to the recording out via email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. We'll make time, hopefully, to answer some of your questions after the main presentation if time permits. And just a friendly reminder that questions answered or advice provided today by either WorkCover Queensland and/or Hall & Wilcox is general information only and should not be taken as legal advice. I'd like to introduce our guest presenters for today's webinar from Hall & Wilcox. First, we have Daisy Duff, Senior Associate of the Financial Services and Insurance team at Hall & Wilcox. Daisy has extensive experience in the common law workers' compensation area and has also acted in the public liability, product liability, medical negligence and CT claims areas. And our second presenter, I'd like to welcome back Angela Brookes, partner of the Financial Services and Insurance team at Hall & Wilcox. Angela is no stranger to our common law webinar series and last presented for us in September 2019. Angela has extensive experience in workers' compensation, product liability and public liability matters. She acts on behalf of state, national and international insurers, self-insurers and Australian and international corporations. A warm welcome to you both, ladies, and thank you for taking the time to prepare and present today's webinar. I'll now hand it over to you.
Hi everyone, as Hannah has already said, my name is Angela Brookes and I have Senior Associate Daisy Duff also with me, and today we will be presenting this webinar. The purpose of this webinar is to provide employers with an update on recent case law decisions in 2020. Firstly, just to take a step back and provide some context to our discussion. Most of you are well aware common law damages may be pursued if an injured worker is able to establish that he or she sustained an injury and that injury was caused by negligence on the part of the employer. Generally speaking, and there are exceptions, a common law damages claim cannot be started until the statutory claim has been concluded. The injured worker's injury has been deemed stable and stationary and a notice of assessment has been issued. Common law claims are usually commenced by the injured worker sending the employer and WorkCover a notice of claim for damages. This can occur up to 3 years from the date of injury. On some occasions, a common law damages claim can still be brought outside the 3-year period if the claimant obtains the benefit of an extension of the limitation period. Now, WorkCover defends common law damages claims on behalf of its insured employers, typically with the assistance of a panel law firm such as Hall & Wilcox. If the injured worker is able to establish that the incident occurred and the employer was negligent, that is, they breached their duty of care they owed to the injured worker and that breach caused the injured worker may be entitled to general damages, payments for past and future economic loss and loss of superannuation contributions. They may also be entitled to payments to cover expenses such as past and future medical, hospital, pharmaceutical, rehabilitation, domestic assistance and care expenses. Typically, the value of a common law damages claim is substantially higher than a statutory claim. WorkCover has processes in place to streamline the conduct of common law damages claims. Even so, as a common law damages claim can usually be commenced at any time within 3 years after the injury, the cases that come before the courts are often heard several years after the injury. In a year where the world stopped, the courts certainly did not. And for the purpose of this webinar, we have taken the opportunity to examine the number of common law personal injury claims that have proceeded to trial in 2020. Our understanding is that there were no relevant trials heard in the Magistrates Court. Now, the Magistrates Court is the first level of the Queensland's court system, and the court hears matters where the amount of dispute is around the $150,000 or less mark. There were 11 district court trials, and this court hears matters where the dispute is in the amount of damages up to $750,000. There were 2 Supreme Court trials, and the Supreme Court hears all matters in which damages are in excess of $750,000 that are being sought. And there was 1 relevant Court of Appeal hearing. In light of the COVID climate, mental health has been a particular focus across all industries, and we appreciate employers have had to run their business and manage their staff under unprecedented circumstances. Today, we are going to take you through some key case law decisions with a particular focus on psychological injuries and the practical learnings for employers who owe a duty of care. And due to the time frame of about an hour and a half, our focus will be on 5 to 6 cases. And notably, out of these 6 cases, the plaintiffs succeeded with respect to their claim against the employer insured on 3 of those matters and failed on the 3 other matters. So I'll just hand over to Daisy, who will be discussing the first case.
Thank you, Angela. Just for everyone out there, my name's Daisy Duff. Angela's introduced me already, but since you can't see me, this is my voice. I'm going to be discussing the matter of Armstrong-Waters versus the State of Queensland. This was a case heard by Judge Morzone in the District Court of Cairns, and the decision was handed down in April 2020. A bit of background. The plaintiff was a registered nurse working in the emergency department of the Cairns-based hospital. The incident occurred back in January 2014. The plaintiff alleged that he removed a blanket from a male patient, following which the patient stood up, verbally threatened and punched him. The 2 then scuffled on the floor until the plaintiff got hold of the patient and forcibly removed him from the emergency room. The plaintiff alleged that the defendant breached its duty of care to protect against the risk of an assault and the risk of a psychological injury in the aftermath of the assault. With respect to the aftermath, this relates to the nature and extent of the plaintiff's interaction with his superiors after the assault. The plaintiff alleged that the aftermath was mismanaged by his superiors. As a result, the plaintiff suffered PTSD and some physical injuries to his knee, shoulder, and back. He claimed $800,000 for loss and damage related to those personal injuries. The defendant argued that the plaintiff had failed to prove any breach of duty, as well as causation, in circumstances where the plaintiff had actually provoked the assault by rigorously removing a blanket from a sleeping, intoxicated patient. The defendant's argument was this: that there was no evidence of an alternative system that ought to have been put in place to manage the risk of assault by patients, and that in any event, any such alternate system would not have prevented the assault occurring. The defendant also argued that the evidence of the plaintiff's co-workers and superiors was that following the incident, the plaintiff had received support via multiple inquiries or advice about whether he was fit to continue working, whether he needed any medical attention, how to seek medical attention by a GP, and also the availability and process of the EAS, or the Employee Assistance Scheme. The defendant also argued that the weight of the evidence established that, irrespective of any reaction to the incident by the co-workers or the superiors, the plaintiff's injury had been triggered by the assault event. In other words, even if there was a breach of duty in the handling of the incident in the aftermath, this did not cause the injury as the assault caused the injury. So the first thing I wanted to point out was the CCTV footage was available, and this was viewed during the trial. The judge noted that the footage showed 2 occurrences before the assault of the plaintiff without warning, swiftly, abruptly, and forcefully removing the blankets off this sleeping intoxicated patient. So whilst the judge considered that the plaintiff's recollection was quite distorted, unreliable, and exaggerated, the judge did consider this was in line with the facts that he had a subjective perception of the traumatic events. The important finding here was that given the CCTV showed the plaintiff was not a credible historian, the judge did not accept the plaintiff's version about how the incident occurred, except where it was consistent with the CCTV or other evidence. Ultimately, the judge did find that the defendant breached its duty of care to the plaintiff, and there's two headings here I'll talk to. The first one is by breach of duty of care by failing to provide staff with refresher training in aggressive behaviour management. So the plaintiff had undertaken a 4-day training session back in February 2008, and you remember that this incident occurred in January 2014. The judge considered that a reasonable person in the defendant's position would have provided staff with timely refresher training. Whilst the judge mentions annual refresher training, he doesn't say that was necessarily a requirement. Such a development opportunity would have enabled staff to familiarise themselves with the predictors, behavioural cues, warning signs, precipitators and triggers of patient aggression, self-regulation and expectations of staff conduct, and also the elevated risks if staff are aggressive and provocative to the treatment of patients. The judge considered that such refresher training, had it been provided, would not have been too burdensome on the defendant and would have reduced the probability of the assault and the consequence of serious injury. The second area which the judge found the defendant breached its duty of care was by failing to identify and train personnel to undertake timely post-incident management. For example, undertaking the debriefing and providing counselling following the incident. The judge found that a reasonable person in the employer's position would have taken precautions to train personnel to quickly coordinate the post-incident response, conduct debriefing, and provide immediate counselling within the 24-hour window. The judge rejected the defendant's argument that it was untenable, implausible, and impractical to act in the immediate aftermath, and found that appropriate support, debriefing, and counselling of the plaintiff would probably have prevented the risk of an aggravation or a more severe PTSD injury following an assault, and that this had no undue burden or expense on the defendant. The judge also considered that the senior nurse on shift, giving regard to her role and duties as being in charge of the emergency department, should have been in a position to provide post-incident management. The judge found that the senior nurse was ill-equipped in dealing with the plaintiff and did not recognise his overt symptoms of PTSD. And these symptoms were that he was angry, agitated, shaking, he rebuffed her offers of support, and he was disengaged. The judge found that her hostile manner towards the plaintiff, her tone and her choice of words during the exchange immediately following the assault was inappropriate and likely to be perceived by a vulnerable person as reprimand and accusatory. Although she offered medical review by a triage, the damage had already been done by her earlier exchange with him. Having concluded that the defendant breached its duty in this way, the question then turns to causation, whether that breach of duty was causative of the injury. In other words, had the defendant done these things, would it even have prevented the injury on the balance of probabilities? The judge considered that the plaintiff's behaviour, which was evidenced on the CCTV to the patient, did show disdain and hostility. The judge noted the established principle of inadvertence, in that employers must take into account the possibility of thoughtlessness or inadvertence or carelessness of their workers. Given the plaintiff was nearing the end of his shift, there was a careless and inadvertent lapse in his training. The judge considered that absent the plaintiff's triggering behaviour, it was unlikely the patient would have assaulted him. The judge found that had the timely and frequent refresher training been provided by the defendant, the plaintiff likely would have acted differently, negating this inadvertent lapse on his behalf. This was because of the plaintiff's reputation for being a dedicated and good nurse who was keen to learn and improve. With respect to the handling of the incident, the judge was satisfied that the plaintiff's exchange with the senior nurse, who was untrained in dealing with such debriefs, did aggravate the plaintiff's condition, resulting in a more severe psychiatric injury. This was due to the reprimand or the accusation that he had misbehaved inappropriately to the patient when restraining him. Accordingly, the defendant's failure to properly identify and train qualified personnel to deal with the plaintiff caused a more severe injury. The defendant was found liable to the plaintiff, and the plaintiff was awarded $357,000 in damages. So if I move on to some practical learnings from that case, the judgment really highlights the need for employers in this type of environment to have detailed procedures in place to both identify and reduce the risks of such incidents, and to appropriately respond when any such incident occurs. So we appreciate this specific case was a hospital environment, but we do see these types of assaults across various industries. The plaintiff ultimately succeeded because of the lack of refresher training in aggressive behaviour management, and I think that that's a good thing to take away. Also, due to the inadequacy of the initial response to the plaintiff by his superior, so this initial response occurred within the 24-hour period, this really highlights the importance of having in place suitably trained personnel to manage post-incident management. So to undertake debriefing or referral for medical treatment or counselling. So it can be the case that the post-incident response can be just as impactful to a worker as the incident itself. The supervision and the actions of the supervisor will also be an important consideration in any case, and it's equally important for supervisors to have specialised training to allow them to meet the requirements of their supervisory role. The last point I make there is one which really rings true. CCTV footage goes a long way to resolve any issues involving the mechanism of injury. We often find that by the time we become involved in investigating these claims, any CCTV has been overridden or misplaced. It's imperative to retain CCTV footage as soon as you're on notice of an incident. I'll hand back over to Angela now for the next summary.
So the next decision that we wanted to talk about today is the matter of Robertson and a state of Queensland. And this particular decision involves a bullying over a period of time psychological injury. The matter was heard before the Brisbane District Court and Judge Barlow QC in March and June in 2019, with the decision being provided in August last year. The plaintiff was an endorsed enrolled nurse employed at the Gold Coast Hospital, and she alleged that she was the subject of bullying, badgering and mobbing by her colleagues at work, mainly registered nurses, over a period of some years. And as a result, she says she sustained a psychiatric injury and therefore is entitled to an award of damages. At the time, the Gold Coast Hospital was actually operated by the State Department, so the claim was against both entities as defendants. Judgment was ultimately made for the defendants, that is, the plaintiff's claim failed. Both liability and quantum remained live issues for Judge Barlow to consider. This means that he needed to determine whether or not the hospital and state of Queensland would be found negligent and responsible for Miss Robertson's injuries, and if so, how much damages Miss Robertson would be entitled to as a result of their negligence. The plaintiff's case in a nutshell was that the defendants owed her a duty of care to take reasonable steps to avoid causing her a psychiatric injury, and that the defendants breached their duty of care and their breach caused her injuries for which she must receive an award of damages for. The defendants' case were in essence that there was no duty of care, there was no breach, and although they admitted she might have sustained a psychiatric injury when employed by them, That was as a result of their responsible and reasonable actions responding to genuine concerns regarding her competency as an endorsed enrolled nurse. There were also concerns on their part, they say, that Miss Robertson was unable to competently administer drugs or provide a reasonable standard of care to patients. Judge Barlow summed up the main issues early on in his decision as follows. Did the events of bullying as alleged by the plaintiff actually occur? That is, was she the subject of abuse? And Judge Barlow ultimately said no. If so, did those events cause her to sustain an injury? Did the defendants have genuine concerns regarding Miss Robertson's competency? And Judge Barlow accepted that they did. And should the defendants have realised that Miss Robertson's psychiatric condition was starting to deteriorate, did they breach their duty of care, and was their breach of care causative? And the Judge Barlow ultimately determined no. So the plaintiff's claim was based on 19 incidents and 6 events which she alleges constituted bullying. During the trial, Judge Barlow made it clear that the only incidents the plaintiff could rely on to constitute bullying were those that are pleaded in the proceedings. This case involved bullying and pure psychiatric illness, and as is often the case in these types of matters, there were complex issues at play. Testing the strength of the witness evidence was paramount. Judge Barlow, as is his role as judge, tested the strength of the plaintiff's evidence and found that while she thought her recollection was honest, it was clouded by her perception of being victimised and was contrary to the weight of the evidence given by the other witnesses. The judge preferred contemporaneous documents and evidence of other witnesses over that of the plaintiff's recollection. Relevantly, Miss Robertson, the plaintiff, kept a diary that she intermittently wrote into at relevant times. Judge Barlow made the point that normally this would constitute contemporaneous evidence, which is usually found to be more reliable. However, in the present case, Judge Barlow considered the diary entries penned by the plaintiff were, in his view, coloured by perception as opposed to an actual record of what had happened at that particular time. There is no doubt that there were concerns about the plaintiff's competency as an endorsed enrolled nurse, and she herself self-commented during cross-examination that she needed some retraining and re-education. The judge commented that her recollection in her diaries were framed in a manner that it saw the bad in everyone else and did not take into account her potential flaws and need for education or re-education by the hospital. The plaintiff also found it difficult to see that any re-education was for her own safety and that of her patients, as opposed to being a form of bullying on their part. Now, as I said earlier, the plaintiff highlighted 19 incidents and 6 events which she says constituted bullying, badgering and mobbing. The bulk of these incidents and events were centred around accusations by her co-workers of incompetency. Out of all of the incidents and events reported, Judge Barlow only found 2 that he said could potentially give rise to and amount to bullying. The first involved an accusation of incompetence with insulin by a co-worker. Conduct that is usually said to be bullying constitutes intimidating or demeaning another person, especially repeated threats to their person, carer, career or social standing, or by harassment in person on social networks, etc. Badgering, according to Judge Barlow, is to harass or torment someone. In this incident, the plaintiff alleges that she was abused and accused of incompetency by a colleague and acting nurse educator. The plaintiff said she was drawing up insulin for a patient via a syringe and drew up more than what was required with the intention of dispersing the extra unit when the nurse educator allegedly said to her, "Do you need your eyes tested?" The plaintiff's evidence is that the nurse educator then asked if she was incompetent before snatching the syringe from her and disposing it. The nurse educator's evidence was that she would have suggested the plaintiff had her eyes checked, as it was important for checking of medications. Here, the plaintiff had drafted a diary note. I need 24 units. I drew 25. So the 25 units was thrown out and Alicia drew up the 24 units. Alicia said, do you need your eyes tested? Me, I've had them tested. Alicia, maybe you're incompetent. The nurse educator did not take a file note. However, she did report this to the nurse unit manager, who recorded that the plaintiff did not know how to read an insulin chart, did not know how to give the insulin correctly, drew up the wrong amount. Now, the defendant said that the nurse unit manager's evidence should be accepted over that of the plaintiff's, and the defendant submitted that the nurse educator was concerned about the competency of the plaintiff. The judge accepted that it was appropriate for the nurse educator to take the syringe away from the plaintiff and ask her if she needed to have her eyes checked. But even though the nurse educator may have been concerned about the plaintiff's ability to perform her role, it was inappropriate for her to say she was incompetent. The judge accepted that by telling the plaintiff she was incompetent, that assertion could amount to bullying or badgering her. However, that in and of itself doesn't demonstrate a pattern of behaviour. The other incident involved an incident which occurred in August later that year, where the plaintiff alleges her co-worker shook her fists and yelled at her for bringing up a patient from the emergency room with chest pain, something that apparently should not have occurred. Here, the judge did not accept that the registered nurse shook her fists, but did accept she may have waved her hands in frustration, and the judge accepted that the waving of the hands could be considered inappropriate. However, again, he noted in and of itself that event did not constitute bullying, but combined with other incidents, it may do so. The judge focused on these two incidents involving the two registered nurses and noted that whilst neither of them had confidence in her abilities and may have disliked the plaintiff, the two incidents themselves were isolated and separated by a period of time. The judge noted that if the registered nurses had repeatedly engaged in this sort of behaviour, either separately or in combination, then that may have constituted bullying and harassment. Ultimately, it was determined that there was no bullying and therefore the plaintiff's case failed. The judge, however, for completeness, did go on to consider duty of care, breach of duty and causation, of course, in the context of psychiatric injury. Relevantly, the judge endorsed the principle that some recognised psychiatric illness may be triggered by stress. However, he goes on to say it is, however, a much larger step to say that all employers must now recognise that all employees are at a risk of psychiatric injury from stress at work. And the judge relied on previous case law and precedents. It does not follow that if such a person suffers a psychiatric injury, then the employer will be liable, and it is important to note that the employer's obligation is only to take reasonable care to avoid a psychiatric injury, and the mere fact that an employee has been exposed to stressful situations in the workplace, even situations that potentially should not have occurred, that does not necessarily make it reasonably foreseeable that the employer will suffer a psychiatric injury. In the present case, the defendants relied on previous case law to suggest that an employer has no duty to an employee to undertake an investigation into that employee's conduct of his or her duties in a manner that avoids a foreseeable risk of psychiatric injury. The defendants submitted that the defendant's conduct in dealing with the plaintiff was akin to an investigation into her conduct and into complaints made by other employees, and so no duty of care was owed to take reasonable steps to avoid such an injury. The judge found that there was no duty of care owed, but even if there was a duty of care found, there was no breach of duty. He accepted the plaintiff had a psychiatric injury, but that it was caused by stresses she experienced in her work at hospital, which was deterioration of her relationships. However, none of the events the doctors say contributed to her illness constituted bullying. The judge also found that the employer was not on notice of a psychiatric condition. The judge, for completeness, assessed the plaintiff's damages, and relevantly, in the present case, the plaintiff was deemed by the Australian Health Practitioner Regulation Agency unfit to practice until she complied with certain requirements such as re-education. The plaintiff alleged she was unable to fulfil certain requirements because of her illness. The defendants assessed her economic loss up until the time she was deemed unfit to practice. However, the judge noted that if indeed liability was established against the defendants, then her inability to fulfil the requirements was caused by her illness, and therefore she would be entitled to full loss. So now I come to the practical learnings that I see from this case. Even if an employee suffers a psychiatric injury in the workplace, it does not immediately follow that an employer owed a duty of care to prevent that injury from occurring, or that the injury was reasonably foreseeable. It is not reasonably foreseeable for an employee to suffer a mental health injury just because he or she is subject to workplace stress or difficult relationships amongst co-workers. If the employer was aware that an employee was subject to harassment or bullying or poor treatment by other co-workers, then that will be relevant to ascertain whether they owe a duty of care to the employee and that that risk of injury was reasonably foreseeable. As regards evidence, it is critical for employers to ensure that their staff keep contemporaneous file notes, reports, statements of incidents or complaints. And these notes should be taken as soon as possible after the incident. Fostering good culture in workplaces is important. Continually educate your staff on embracing positive, transparent relationships with each other and their leaders. Encourage networking where possible. Adopt a zero bullying policy. As employers, remember every staff member is different. You don't know what may be impacting them outside their workplace. Encourage check-ins. Encourage them to tap into employee assistance programs. Educate them on what is available to ensure their individual well-being. If a staff is performing poorly, ensure that you adequately manage their performance. Ensure good record keeping of performance management issues and discourage gossip amongst co-workers. Professionalism in these circumstances is key. It is also important, we believe, for employers to appreciate how long it can take for a matter to be heard before a judge. In this particular decision, circumstance and case, the alleged incident and events occurred in or around 2011, 12 and 13, and it was being heard before a judge in 2019. This may have implications on the damages awarded for the plaintiff if they haven't been working since the alleged events, and that unemployment is as a direct result of the alleged work-related incident. But it also, and perhaps more importantly, refers to the point that I've previously made and Daisy's also alluded to, which is that contemporaneous reporting is so important, as that is typically found to be the most accurate and reliable evidence. So now I hand back over to Daisy.
Thank you, Ange. I'm going to cover the case now of Giles versus the State of Queensland. This case was heard by Judge Reid of the Brisbane District Court, and the decision was handed down in December of 2020. Just for full disclosure, our firm, Hall & Wilcox, acted for the defendant in this case. By a bit of background, the plaintiff was a firefighter. He was on shift on the 24th of August 2011 when the tragic house fire at Wagensfeld Street in Slacks Creek occurred. 11 people, including 8 children, lost their lives in this fire. There was no doubt that the plaintiff developed a significant psychiatric injury as a result of his exposure to this fire. Specifically and importantly, the plaintiff's case was that his injury was a result of his prolonged exposure to the traumatic scene and the understandable demonstrous grief of the community that had congregated shortly after his arrival at the scene. As the pump operator, The plaintiff was required to remain with the truck, which was located approximately 15 to 20 metres from a police barricade and the crowd. The plaintiff was not involved in the physical firefighting and did not view the deceased. The key issue was whether the Queensland Fire Service was negligent in their management of the plaintiff at the fire, and whether such negligence was causative of the plaintiff's subsequent psychiatric illness. This was vigorously contested. The defendant argued that the Queensland Fire Service had discharged its obligations to take reasonable care of the plaintiff by firstly determining the number of personnel at the fire would be limited by not rotating crews, and secondly, taking steps to monitor the plaintiff's well-being during his attendance at the fire. The plaintiff argued that the Queensland Fire Service had failed to discharge its duty because they failed to rotate him out, or alternatively to undertake appropriate questioning and welfare assessment of him. The plaintiff claimed for $684,000 in damages and loss as a result of the psychiatric injury he suffered. The credit of the plaintiff in this case was a highly critical factor in the determination of the claim. This is because the plaintiff's evidence about what distressed him at the fire, what his level of observable distress may have been, and what he was told by those managing him on the day are all of high importance to the determination of liability. For example, the plaintiff had alleged that his immediate supervisor on site spoke to him only twice and denies that any other officer, including the safety officer, spoke to him about his welfare. The defendant's witnesses, who were the supervisor and the safety officer, gave contrary evidence. The judgment deals with the plaintiff's credit in detail, but I won't summarise all of these items for today's purposes. Ultimately, the concern related to the fact that the plaintiff had unrelated physical conditions, which were relevant to his ability to continue employment in any event, so relevant to any calculation of damages, keeping in mind this claim related to a psychiatric injury. The plaintiff alleged that these unrelated physical conditions had little impact on him. The defendant argued that the plaintiff's medical records, the treatment he had received, and the opinions from specialists indicated that the unrelated physical conditions were of significant restriction. The defendant argued that given the plaintiff's evidence about the conditions having very little impact on him, this should cause significant doubt to be placed on the plaintiff's credibility and reliability. The defendant also argued that the plaintiff's version as to what occurred at the fire should be doubted, as well as his history, given regard to the development of his PTSD after the night, as well as his other evidence. The plaintiff argued in response that significant allowance should be made by the judge when assessing the plaintiff's credit, given the plaintiff's anxiety and other symptoms from his PTSD. After reviewing the evidence in detail, the judge found that the failure of the plaintiff to be frank about his symptoms of the unrelated physical conditions led him to have real doubts about the plaintiff's honesty. Also, his failure to recall prior psychological symptoms and treatment before the fire, compared to the medical records evidencing such treatment and symptoms, led the judge to have concerns about the reliability of the plaintiff's memory about historical events. Therefore, the judge reached an adverse conclusion about the plaintiff's credibility and reliability, and I'll outline the impact of this on the plaintiff's case shortly. So it was undisputed that a conscious decision was made by the service to keep the plaintiff and his crew at the fire, rather than to rotate them out and to rotate in a new crew, exposing more personnel to the trauma of the fire. The question was whether there was a failure to rotate the plaintiff away from the scene at an earlier point in time. The question was not only whether this decision not to rotate was a breach of duty, but also whether, had the plaintiff been rotated from the fire earlier, this would have prevented him sustaining injury in any event. Expert psychiatric evidence was heard on these points. The plaintiff called Professor Samuel Harvey, a psychiatrist, who expressed the opinion there was a clear link between the time of exposure to trauma and the risk of sustaining PTSD. Namely, Professor Harvey expressed the opinion that being exposed to a traumatic event for a longer period increases the risk of sustaining PTSD, and that to have limited the plaintiff's exposure by rotating out his crew within a shorter period would have or might have avoided him from suffering the PTSD. So to support these opinions, Professor Harvey referred to a number of studies. These studies were critically reviewed through cross-examination. Ultimately, the judge made findings that the studies referred to by the expert to support his opinion were not necessarily strongly supportive of the opinions he offered. As an example, the plaintiff was present on site for 9 hours. One of the articles referred to by the expert to bolster his argument related to exposure of American firefighters to the 9/11 scene. As you can imagine, the study in relation to the 9/11 firefighters related to exposure to a scene of over 200 days, whereas the subject case related to exposure to a scene over a number of hours. The judge then accepted the evidence of the defence's psychiatrist, Professor Whiteford. And I'll just read out this quote from Professor Whiteford's evidence. It is impossible to know whether, in the hypothetical situation, assuming this man's removal from the scene at an earlier point in time after arrival, he would nonetheless have developed a PTSD, and if so, of what severity? In other words, even if the plaintiff had been rotated out after a number of hours of exposure, this would not necessarily have prevented the incident. Therefore, there would not have been an established causal link. Professor Whiteford also provided the opinion that a low-key inquiry was a reasonable way to monitor the plaintiff's well-being to ensure he was coping with the prolonged exposure, or if he was becoming increasingly distressed over time. Likewise, the plaintiff's psychiatric expert also indicated that an acceptable alternative to the decision not to rotate out the plaintiff's crew was for the service to take reasonable steps to monitor his level of distress. The judge accepted that welfare checking was a reasonable alternative. So the judgment then turned to whether the welfare checking undertaken with respect to the plaintiff was reasonable and adequate. As a result of the credit findings, which I've discussed earlier, the judge found that the plaintiff has only a poor recollection of the details of the events of the night and did not accept his evidence about the contents of his discussions with the supervisor and the safety officer. The judge accepted the supervisor's evidence that he had made inquiry with the plaintiff on at least 2 occasions during the 9 hours at the fire, if not more. There was a great deal of cross-examination of the supervisor regarding the substance of his inquiries. The plaintiff's allegation was that the substance of the inquiries from the supervisor were operational only, so not from a welfare perspective. The supervisor disputed this. The plaintiff alleged that at the time of the second occasion, the plaintiff had told the supervisor, "This is just not right." And he clarified that he meant it was not right that so many people couldn't be saved. The judge accepted that during these inquiries, the supervisor had given the plaintiff an obvious opportunity to enunciate any distress he was feeling, and the judge found that the plaintiff did not do so. The judge was satisfied that if the plaintiff had told the supervisor he was distressed, the supervisor would have done something about it. With respect to the safety officer, he gave evidence of checking on staff to watch for stress and anxiety, and he recalled 2 specific occasions of checking on the plaintiff, once early on when he was outside of the truck and once later on when he was inside the truck. The safety officer could not recall the words used, but noted his safety officer role was to make sure everyone was okay and there was nothing in the conversation that had raised any concerns to him. The judge noted that the safety officer's frankness in admitting where he was unable to recall details enhanced his credibility, and the judge accepted his evidence. The judge ultimately found that the inquiries made by the supervisor and the safety officer were sufficient to adequately monitor any distress, and that there was no basis for concluding that the Queensland Fire Service was negligent in its management of the plaintiff on the night of the fire, and the plaintiff's claim was dismissed. This matter is the subject of an appeal, which is yet to be determined. With respect to practical learnings, you'll hear us talk about this a lot today, credibility. It can have a significant impact on the findings of the court, especially in a case which turns heavily on witness oral evidence and recollection of witnesses of events which have occurred years previously. For this case, the trial was heard just before the 10-year anniversary of the fire. Welfare checking, where an employee is required to be exposed to a potentially traumatic scene, welfare checking periodically is imperative. Again, whilst this is a fire service case, a more practical example is welfare checking of witnesses who might witness a specific injury or who might be experiencing confrontations in the workplace. Training superiors is also a practical learning from this case. There was an allegation by the plaintiff that the service was negligent in failing to identify and educate its senior staff in critical stress impact of prolonged exposure to traumatic events. The judge considered that there had been no evidence given as to the manner and form of the education of senior staff, which ought to have been implemented, and so this allegation did fail. But we raise it as an important issue because it comes back to ensuring that supervisors have adequate tools and training to make such inquiries, to handle these discussions, and to identify basic signs of welfare concerns. I'll hand you back to Angela now.
The next case that we wanted to discuss, the next decision, is Healy and Logan City Council. It was heard by Judge Sheridan in the Brisbane District Court in May 2019, with judgment being delivered in April last year. The plaintiff was employed by Logan City Council as a cleaner at an indoor sports centre. She alleges that she injured herself whilst cleaning after a major event. She fell off a row of seating in a grandstand and suffered an injury to her left shoulder. Her duties as a cleaner was to use a squeegee and push rubbish left by patrons in the footwell along to the aisles to be collected. And her claim was ultimately dismissed. Whilst this isn't a psychiatric claim, we wish to discuss it today because it deals with several issues that are often common allegations found in personal injury claims involving employer-employee relationships, and that is the allegations of failure to risk assess, induct, train, supervise in the context of performing a task under time pressure. So both liability, including contributory negligence and quantum, were an issue in this matter. The key issues were whether the defendant breached its duty of care and whether the injury was the cause of the plaintiff ceasing work. The plaintiff alleged that the council required her to stand on the rows of seating to clean the aisles, or in the alternative, failed to tell her not to stand on the aisles and train and instruct her accordingly, failed to give her any assistance to perform her task so she didn't rush, and should have provided bins or containers in which patrons could deposit rubbish so she didn't have to clean the aisles in the manner in which she did at the time of the incident. Again, the witness evidence was important here. The plaintiff gave evidence, and for the plaintiff, a past employee also gave evidence. He was the front of house team, and his evidence was that he had observed the plaintiff cleaning by standing on the seats. The defendants, so counsel, called 3 witnesses, all co-workers, a venue operations coordinator who supervised the cleaners, front of house team leader who completed the online or on-site induction with the plaintiff, and a cleaner who was responsible for showing her around as part of the induction and who worked with the plaintiff as a buddy on 2 shifts. There was a conflict in evidence. There was a dispute as to whether or not there was any instruction given as to the standing on the rows of seating in the grandstand and whether the plaintiff cleaned or was cleaning by standing on the seats when she injured herself. The evidence of the venue operations coordinator who witnessed the incident said the plaintiff was traversing down the grandstand whilst calling to the coordinator and tripped on the edge of a row of seating. His evidence was that she was not walking on the seat for a number of steps prior to slipping. His evidence was and in quotation marks, to the best of my recollection, she had come off the stairs by the time I saw her, but she looked as if she'd come from the stairs and her route of travel was across the footwell, diagonally across the footwell, not perpendicular to the seats. No one else saw the incident. The evidence of the cleaner was that she had given the plaintiff instruction not to stand on the grand seats, and she had provided the plaintiff with on-the-job training and instruction on how to clean the grandstand. The evidence of the cleaner was that she also trained the plaintiff via a buddy system. The cleaner had been employed by the council for 10 years. Her evidence in quotation marks was, "I would never have told Miss Healy to stand on seats. One of the first things I mentioned to any new cleaners, that when cleaning the grandstand, you were never to stand on the red seats because they are really slippery." The judge accepted the evidence of the defendant's witnesses, including that cleaner, over the plaintiff, and noted their evidence was frank, coherent, and provided in a forthright manner. Specifically, the judge accepted that with the direction of travel, that the coordinator had observed the most likely cause of the fall was that Miss Healy was crossing over the seat in a traverse down the grandstand towards him, and she tripped by her toe clipping the edge of the seating. He did not accept that the fall occurred as a result of the plaintiff slipping from the row of seating while she was cleaning. The evidence was that there was no documented procedure as to cleaning of the centre of the grandstand. There was nothing in particular induction documentation to reference any prohibition or direction of staff members not to walk on the seats in the grandstand. However, the judge noted that no evidence was led by the plaintiff as to, even if a risk assessment had been documented, what should have been the results of the risk assessment. The judge held that it is probable that a risk assessment would have concluded that the rows of seating were slippery and people, including cleaners, should avoid standing on the rows of seating. However, he accepted that given the evidence of the cleaner, which he accepted as to the instruction given, his view was that a formal risk assessment wouldn't have made any difference. The evidence put forward from the ex-employee called by the plaintiff wasn't accepted. The judge also didn't accept the task was rushed. Further, he reported that there were no further suggestion that the conduct of a risk assessment would have identified the need for changes to staffing arrangements in any event. Relevantly, the judge noted, in line with previous case law, that whilst an employee does owe a duty of care, it's not obliged to safeguard employees from all perils. The employer only has a duty to take reasonable care to avoid exposing employees to unreasonable risks of injury, and to take reasonable steps to provide a safe place of work and a safe system of work. In the present case, the judge accepted that there was a risk that an employee will slip and injure themselves if they were allowed to clean the grandstand by standing on the rows of seating, and there is no doubt that that risk of injury was not insignificant. The real issue in the case was what precautions the employer ought to have taken and didn't take that would have avoided the risk, and the onus of that is on the plaintiff. To this end, the judge accepted the following precautions were taken by counsel: a site induction, on-the-job training involving buddy shifts with an experienced cleaner. The judge accepted that the plaintiff was advised not to stand on the rows of seating when cleaning by the cleaner, general supervision by the event coordinator, and wheelie bins were taken out on major events and announcements were made for patrons to pick up rubbish, etc. The judge ultimately concluded that the training and instruction provided was reasonable and it was not required for it to be in written form. It was impractical to put wheelie bins in grandstands as it would have impeded on pedestrian traffic. A formal risk assessment would have made no difference given she was verbally instructed. Yes, a risk assessment would have determined that the plastic seats were slippery and should not have been stood upon, but an appropriate instruction to that effect had been given to the plaintiff, and no additional assistance would have prevented the incident. The judge also went on to consider contributory negligence and said, as he would have found that the council knew or ought to have known what she was doing and they didn't take any steps to stop her, Of course, we know that that's not what he found, but if he did find that, he would have equally found the plaintiff responsible for 30%. That is, she contributed to her injuries by standing on the seats to perform her duties when she was told not to do it by a person and clearly was performing a dangerous activity. From a damages perspective, the issue arose as to why she resigned from her job. Was it due to the alleged injury or some other non-work related reasons? And the judge accepted the evidence that she just didn't want to work and failed to make any attempt to find alternative employment opportunities. And ultimately, the award for economic loss was modest. So practical learnings from this is, in my view, that it's not critical to have written documents outlining procedures and systems of work. However, it is useful to do so as it provides further evidence for the judge to consider. Just because a risk of injury is reasonably foreseeable and not insignificant, that doesn't mean an employer will be liable, providing the employee can point to the precautions they have taken to avoid the risk of injury, and those precautions were reasonable. When looking at their systems of work and training, employers should consider what further additional precautions, if any, could be taken by a reasonable person in the position of the employer to prevent the injury. And this case largely turned on what evidence the judge preferred. And it is important for employees to recognise that it will ultimately be up to the judge, should the matter proceed to trial, on which evidence he or she wishes to accept and prefer.
Thanks, Angela. I'll just discuss this one of Funnell versus Michael Hill Jeweller Australia. So this one was heard by Judge Kent in the Southport District Court. It was actually delivered in December 2019, but we thought it would be a good one to discuss today. Background-wise, the plaintiff was a sales assistant. She was employed by Michael Hill Jewellers. In November 2015, she was the victim of an attempted robbery. While she suffered minor physical injuries, she subsequently developed a significant psychiatric injury. A male customer entered the shop, viewed a gold necklace and matching wrist chain in a display cabinet, asked for the price from the plaintiff, and she said $13,000. The male customer then asked if that was the best price, prompting the plaintiff to remove the necklace from the display cabinet and to scan it at the computer. She then walked back to the plaintiff and advised him a different price. The male customer asked to feel the weight of the necklace. The plaintiff asked the customer to produce his driver's license in order for him to inspect the necklace. The customer then moved to his right as if to grab his wallet and suddenly and aggressively reached over the counter and grabbed the necklace. There was a struggle, the chain broke, and the customer fled. The plaintiff alleged that the defendant was negligent in failing to provide a system of work. There were a number of alleged failings by the defendant, including a failure to have security guards at the store, a failure to have different doors that closed in the store to prevent an easy escape, a failure to alert customers to the fact that CCTV was operating in the store, and the failure to enact a policy prohibiting staff from retrieving expensive items of jewellery from display cabinets until customers had provided a valid driver's license. The defendant denied the causal link between the plaintiff's injury and any of her allegations, in that none of them was a necessary condition of the occurrence of the injury and that none of the allegations would have prevented the injury. The defendant also alleged that none of the alleged precautions were reasonably required. The defendant argued that the plaintiff had a pre-existing condition, being pre-existing alcohol abuse and symptoms of PTSD following various incidents in her past, and that any psychiatric injury suffered as a result of this incident was a short-lived exacerbation of the pre-existing condition. Now, foreseeability, this was disputed by the defendant, who called evidence from Professor Whiteford essentially indicating that a person of normal fortitude would not have suffered a psychiatric injury as a result of this event. This relates to the plaintiff's pre-existing history and an argument that it was therefore not foreseeable. Foreseeability was established with the court accepting that the experience of being a victim of a violent crime gives rise to a foreseeable risk of psychiatric injury, which was not insignificant. The judge did not accept that a standard of normal fortitude is a precondition or bar to foreseeability. The judge accepted the defendant's evidence that a security guard would be problematic due to the expense and possible effectiveness. Likewise, security doors were unlikely to have prevented the injury, as with applying signs concerning the use of CCTV cameras in store. At the time of the attempted robbery, the defendant's policy was to require staff to secure identification to view items of jewellery valued at over $20,000. You recall this necklace was $13,000. Following the incident, the defendant adopted a policy reducing this monetary limit to $2,000. The judge considered that reducing the monetary limit to $2,000 was not an overly expensive or onerous action prior to the incident, and that a reasonable person in the employer's position would have taken this precaution. The judge considered that given the nature of the defendant, Michael Hill Jewellers, which is a large multinational corporation whose business involves small, valuable items retailed through many outlets, employing many people such as the plaintiff, and which had, on the evidence at trial, suffered many such incidents in the years leading up to the incident, it should have informed itself and assessed that risk. There was a lot of discussion in the judgment and evidence about the defendant's system of recording and learning from such incidents, which appeared to have not been undertaken by the defendant. The defendant argued that the scope of liability should not be extended where it was not aware of the plaintiff's pre-existing vulnerability. However, as discussed, the judge concluded that an injury of the general same type was nevertheless foreseeable, so the vulnerability, if any, did not reduce the scope of duty on the defendant. Finally, the judge considered that had a $2,000 limit safety policy been in place, the plaintiff would have followed that policy and the injury and the snatch and grab would not have occurred, negating the injury. The plaintiff was successful. Given the plaintiff's pre-existing psychiatric condition, I wanted to focus a bit on the impact of this on her quantum assessment. The plaintiff argued that the incident had a profound adverse effect on her pre-existing condition, that she was managing her employment well prior to this incident, and that her attempts to return to employment since the incident had been unsuccessful due to the aggravation from the assault. The plaintiff argued that although she would have been required to become a carer for her parents in any event, she would have continued working part-time and then returned to full-time at a period in the future. The defendant's argument was that this incident provoked a short-term exacerbation of the plaintiff's long-standing condition. The defendant argued there was no good reason for the plaintiff to have left employment with her various post-incident employers, and that this was just a voluntary choice rather than being causally related to the incident. The defendant argued it was doubtful the plaintiff would have been able to return to part-time employment whilst acting as a carer for her parents. The judge accepted the evidence of the plaintiff's psychiatrist, Dr. Foxcroft, that the plaintiff's pre-existing condition was in remission prior to the incident. The judge accepted that due to the plaintiff's pre-existing difficulties, she was at risk of her working career being somewhat tenuous, as it was prior to the incident. While she had worked consistently in retail, she had done so for various employers for varying and sometimes short periods of time. The judge did apply discounting to the assessments of past economic loss at 10% and future economic loss at 35% to take into account the less than fully secure work. This encompassed her pre-existing health issues, but also the nature of her work, the difficulties with her employment pre-incident with the employer, and the requirement to care for her parents. Practical learnings. It's well known there's a duty on the part of the employer to have in place policies to protect workers from potential injury. The court noted that there is a high degree of responsibility imposed on an employer to avoid foreseeable risks of harm to its workers from criminal conduct of third parties. This case highlights that the inherent risks in an employee's role are an important consideration in determining what exactly are the reasonable precautions that have to be taken to meet an employer's duty of care. Also, review the risk assessments. The employer had a policy following a review in 2005. There's a lot of discussion in the evidence and discussion by the judge about a failure to record and consider the incidents that had occurred since the 2005 policy and to review their risk assessment and update it. Also, with respect to the impact of pre-existing psychiatric conditions, this often comes up in pure psychiatric claims. Although a person has a psychological condition before an incident, each case turns on individual circumstances, and such a condition will not necessarily have a large impact on quantum. I'll hand back over to Ange now.
Excellent. I'm conscious of the time and information overload. I'm not going to go through the last case on the slides, other than to say that John Kinane and I did discuss this, the district court decision in our webinar in 2019. In essence, the state of Queensland appealed the decision, which was that the employer was found to be in breach of its duty to the plaintiff by failing to implement a reasonable solution into their system of work, which the court was convinced would have avoided the incident in its entirety. The state of Queensland appealed the decision, the main ground being that there were several difficulties with the system held to be required by the trial judge, but the appeal was ultimately dismissed with costs. So the practical learning with respect to this Court of Appeal decision is just the importance of maintaining a safe system of work, particularly when the risk of serious injury is high and the reasonable steps are relatively minor. Thank you so much for giving us the opportunity to discuss the recent case law with you today. There are other decisions that were made in 2020 that we just didn't have time to discuss. All of the decisions are published and can be located on the court website, and WorkCover's website also contains very useful online summaries of case law. So over to you, Hannah.
Too easy. Thank you, Daisy and Angela, for presenting today. We appreciate all your hard work, and we think it's been a very engaging topic. So we hope that our audience has walked away from this with some information that they can use. And to our audience, thank you for tuning in. As mentioned, we will send out a link to this recording at some time early next week, and please keep an eye out for promotions as to what our next webinar will be in the next coming weeks. So that's all from us here today at WorkCover. Stay safe and have a great rest of the day.